Good morning, everyone. For the record, I'm Damian Leonard from the Office of Legislative Counsel. I'd like to call the Unemployment Insurance Study Committee to order. The first order of business for the committee is the election of a chair.
I nominate Representative Kornheiser.
Second.
All those in favor?
Aye.
Aye.
Okay. The second order of business, if the committee would like, is the election of a vice chair, and then I will hand the meeting over to Representative Kornheiser.
Oh.
I'd like to nominate Senator Clifton.
All those in favor?
Aye.
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 Okay.
I think you're outvoted.
We have a chair and a vice chair. Madam Chair.
Thank you. I think next on our agenda here is a review of the committee's statutory charge. If you could start that up, Damian. Thank you.
Well, for those of you watching on YouTube, I'm going to share my screen and it should pop up on the screens in the room here. Great. Go ahead. Okay. So we've made it through the appointment of a chair and vice chair. Next, we'll move to the statutory charge and then the federal and state legal backgrounds. And hopefully we'll get through that before we take a break. So the statutory charge for the committee provides that the committee shall study the following issues. The solvency of Vermont's Unemployment Insurance Trust Fund and the amount necessary to ensure that it remains solvent and able to continue meeting the needs of claimants during a future economic recession and subsequent recovery. The adequacy and appropriateness of Vermont's unemployment insurance benefits, whether Vermont's benefits should be increased, and whether the Vermont statutes related to the benefits should be modified in any manner. Instances for which it may be appropriate to provide the Commissioner of Labor with authority to reduce or waive a period of disqualification imposed in relation to a determination of unemployment insurance fraud. And likewise, instances when it may be appropriate to provide the Commissioner with authority to reduce or waive an individual's liability to repay overpaid unemployment insurance benefits. And then finally, potential statutory changes to mitigate the impact of benefit charges attributed to reimbursable employers who paid wages to a claimant during the claimant's base period, but did not cause the claimant to become unemployed. Before I go on here, I think it'd be worthwhile just to mention some of the other studies that are happening concurrently with this one. So there is a review by the state auditor of the fraud prevention measures at the department that is going on concurrently. There are also, and that's, there is also 2 different reports that are due in December related to employee misclassification. One relates to the dual enforcement by the Attorney General's office in the department that we enacted a couple of years ago. The other is a look by the misclassification task force at ways to improve on that dual enforcement mechanism, as well as other ways to improve the enforcement of the statutes against misclassification across state government. So better ways to coordinate work between, for example, the tax department and the Department of Labor. Liquor and lottery does some of the enforcement with them in relation to licensees, et cetera. So they're tasked with coming back to us with a report on further improvements that we could make. Are there questions about those before I move on to some of the details for our work?
Just want to add that it's my hope that we can let the separate task forces and committees and reports do their job while being conscious enough of where they're going so that maybe everything could come together in the end in some magical synergy of legislative studies. Thanks, Damien.
Moving on with the statutory charge for this committee, in studying the issues that I just highlighted, the committee is directed to compare Vermont's unemployment insurance system with other states and to specifically identify best practices and high-performing aspects of those states' systems, to look at or identify shortcomings, challenges, and opportunities to improve our own system, to identify potential changes and improvements to the department's staffing, resources, IT, training, funding, communications practices, and procedures as necessary to address those identified shortcomings, challenges, and opportunities. And then any potential statutory changes necessary. And then finally, to the extent possible, the anticipated cost of implementing these changes and improvements, if there is any. So the committee has funding for 3 meetings. You're not restricted to 3 meetings, but if you go beyond 3 meetings, you will not be able to get reimbursed for travel and daily expenses. And then finally, as far as a report, this committee is required to submit a report on or before December 15th to the House Committees on Appropriations, Commerce, and Ways and Means, and the Senate Committees on Appropriations, Economic Development, and Finance regarding its findings and any recommendations for legislative action.
Madam Chair. You mentioned that we can go beyond 3 meetings, but we couldn't get paid.
That's correct.
Could we do an extra meeting on Zoom if necessary?
So I would have to defer to your, to the Senate Secretary and the House Clerk on whether we can do business fully remotely. But it's, that's the only concern I would have about that, is that you may or may not be able to actually do business over Zoom. And I can't remember what the specific rules are for joint meetings. I know for the House meetings, you have to have a quorum present to vote and conduct business. I don't know what the rules are when it's a joint meeting. So we would just need to check on whether we can do that.
Because I noticed on today's agenda that we were offered the opportunity to come on Zoom or not.
Mhm.
That if we had all showed up on Zoom, that would have been a problem.
My understanding
Go ahead.
My understanding when I looked into this for a different meeting was that we can't make any decisions via Zoom, and we can't vote, and we need to have a quorum in person. And so if one person is Zooming in, that's fine and an appropriate accommodation to make, but we can't conduct business essentially via Zoom. We can talk about opportunities for other meetings maybe at the end of the day though.
Yeah, and there are joint committees that have met where they didn't have a quorum present, so they just took testimony and then adjourned without making any votes or anything like that. So if that's necessary, that's something that potentially this committee could look at doing.
Could you remind us the deadline for bill filing and whether or not it applies to, I know it's early, I think it's before December 15th for the Senate, but does that also apply to committee bills?
I will find out and get back to you after the break on that.
Okay.
I can't remember the exact deadlines. But it is early December. Any other questions? Okay, well, that brings us to the legal background. So first, I'm going to start with unemployment insurance financing, which is shorthand for trust fund solvency. At the end of the day, what it gets down to for this is essentially how you set up the tax structure for the unemployment insurance trust fund. There are going to be other factors that impact it, such as the amount of benefits going out. But at the end of the day, this is ultimately about how do you finance the system through the tax structure. So the USDOL does not have an official standard for trust fund solvency. However, under federal regulations, One of the conditions for a loan from the USDOL to be interest-free is that the state, as of December 31st of any of the 5 consecutive calendar years preceding the calendar year in which the loan is made, the state had an average high cost multiple of at least 1.00. I'm going to talk about what that means. This is also the amount that USDOL recommends in guidance documents as a sort of solvency goal to be at or above this 1.00 multiple. I am not an economist. I'm not an expert on this, so you may get expert testimony later on that says that this is adequate or inadequate. I'm just giving you what the USDOL has put out there. So what the average high cost multiple is it essentially takes the total fund balance divided by the total wages, and then it divides all of that by the average high cost rate. So the average high cost rate is the average of the 3 highest annual benefit cost rates in the last 20 years, or if you've had particularly long periods between recessions, the last 3 national recessions. So basically you're looking at, for us, this would be like 2009, 2010, and 2020 right now if we did this, and it would average those 3. So what this does is it avoids a little bit of the issue that we have in our current system where we take the highest benefit cost year in the last 10, which, as we remember from last session with the 2020 benefit payout, it got the trust fund formula deciding that it needed about $1 billion to be solvent. And this would instead give us an average number that includes the last recession, might mitigate that 2020 year a little bit. The downside is if you have a particularly mild recession, it can lower that number. Say you had 2 mild recessions and then 1 serious one, that serious recession could be heavily mitigated by those mild recessions. So there are benefits and drawbacks to using this multiple, but that's the basis that USDOL uses to try to get sort of an average solvency number.
When you say total wages, is that annual wages of Vermont workers?
So that's total wages that are covered by unemployment insurance in the system. So for work that's not covered by unemployment insurance is not included in that.
Okay.
I don't think this is total taxable. This is total wages for employment that's covered by unemployment insurance. So for Vermont, this wouldn't cover, for example, individuals who work for a very small nonprofit, individuals who are doing work that's otherwise disqualified from getting unemployment insurance, that sort of thing. But this would include the total wages for everyone who's eligible for or potentially eligible for unemployment insurance. Does that make sense?
That includes reimbursable employers?
Yes. Yeah. So this,
Where does
I believe this includes reimbursable employers.
where would the figures for those wages come from?
Reimbursable employers file quarterly
They do.
wage reports the same as contributing employers. The difference is just what happens when they have benefits charged, they're billed to reimburse the benefits rather than getting a tax rate that applies over the course of the year. So under this particular model that the USDOL has used as a guideline, the 1.0 multiple just basically means that you have reserves in your trust fund that would be sufficient to cover the cost of 1 year of average recession benefits. When we talk a little bit later this morning, I'm going to go through some charts that kind of show you experience with several recessions from the last 40 years. And it looks at, for folks who had an AHCM of 1.0, how many times did they need to borrow? For folks who had an AHCM below or above, how many times did they need to borrow, and it breaks that down. There's also a trust fund financing document from the USDOL that I included in the handouts that are posted online. It's 76 pages. It is surprisingly easy to read for a financing document, but it goes through all of this in much more detail than I can cover this morning. So if this is something you want to dig deeper into, I would suggest starting with that document to give you a good background. It has examples from, they use California as their example, that they talk about if we do this to the way we fund taxes in California, adjusting the taxable wage base, what happens? If we aim for an AHCM of X, what happens? And so it kind of gives you an idea of how you would design the funding system. So if we decide, for example, that the formula in Vermont is reaching a balance that's too high, this gives you sort of the background you need to understand what sort of adjustments might we want to make to bring that down, and vice versa. If we decide that we have inadequate funding, what adjustments do we have to make to bring it up to an adequate level?
But under that, there are no penalties to the states if they fall below the 1.0.
There are not. There are potential penalties when you get into a borrowing situation with the federal government. There, you run into potential penalties if, for example, you make changes to your law which would not fully replenish your trust fund. So, for example, if you're in a recession and you cut taxes to the point where your trust funds can be losing money, then you potentially run into issues in terms of being able to get a Title 12 loan from the federal government to cover your shortfall. That gets a lot more complicated, and it's somewhat outside of the issue of just baseline financing. But looking at that sort of financing model, this is one guideline they use, and then in their document, providing recommendations for states who have inadequate financing following the Great Recession. This was what they were recommending states look at, and the document's from 2017, so it predates the COVID-19 pandemic. I don't know if they would update it in light of what happened during the pandemic. But again, this afternoon, I'll show you using the AHCM measure, what happened to Vermont's trust fund from January 1, 2020 to January 1, 2021 during the first 9 months of the pandemic. It was a pretty dramatic change in terms of Vermont's level of financing over that time. And that may also give you some context into whether or not Vermont's current model is adequate. So
Just to clarify, but the multiple of one is still a recommendation.
it's a
and-
recommendation, not a requirement.
Great. And so there are no requirements outside of borrowing,
Yeah, so
That's
when you get into a borrowing situation, there's all sorts of
but we don't,
standards you need to meet to get your, to either get the loan interest-free
not asking
or
about
to
that.
avoid
Okay.
tax increases on your employers or to cap those tax increases. So, and that actually brings us to our next point here. So there is a 6% federal unemployment tax rate. Most states that are not in a borrowing situation get a 5.4% credit against that tax rate. So that credit is based on what the baseline tax for states is, and then states are allowed to provide rates below that tax based on 3 years of experience. This is where experience rating comes in our system. And they're also allowed to provide new employers with an initial tax rate of 1% or above. So if you don't have enough experience, you can, by state law, provide for a 1% tax rate. We provide for both a new employer tax rate as well as lower tax rates for employers with better experience ratings. And then in order, the base tax credit on the federal is based on the amount of state taxes you pay. So if you're below that, what your state needs to do is be in conformance with federal law to get the additional tax credit to get you the full 5.4%. That's where we get into, again, some of these issues of conformity. There are two ways the federal government kind of forces states to stay within the guidelines that it's set in the federal unemployment tax law. The first is the tax credit. The second is administrative funding. And when you fall out of conformance, both of those are at risk. The conformance issue, I'm sure we're going to talk about more this afternoon. So I'm going to leave that alone for now, but those are the two things that are at stake when we have potential conformance issues.
Question.
Chair.
So back in 2009-10, there were a lot of states that were in the red, correct?
Yes, a lot of states went into the red.
And unless they have a plan to come out of the red, they could be imposed with a 5.4% federal.
So
Employers can be imposed with a 5.4% tax.
the additional tax, it's not all at once, but it's based on issues of, are you paying all of your interest by November 9th of each year? And then, and so that's one of the main requirements is states have to pay the interest on their federal loans by November 9th. There are ways to avoid having interest due. But we did have, my understanding, and I wasn't even admitted to the bar in 2009, I'll admit it. My understanding is that we did have a short-term hike in federal tax rates as we paid off our loan, and then that went away. And the state ended up having to appropriate additional funding to get that loan paid off quickly to get us back on good footing in terms of the unemployment system. And then as all of you are aware, there were significant changes made to both taxes and benefits at the time, and what's commonly called the grand bargain, to get the system back on a trajectory where we would get a healthy trust fund, which we reached. We reached the lowest tax schedule right as the pandemic was starting.
I guess what I'm interested in knowing is, did employers of this state ever have to pay directly that 5.4% tax?
I don't think employers paid the full amount, but I do think they paid an additional federal tax, and I'm seeing Representative Marcotte not as heavy.
1 year of 6%, I believe.
Oh, it went to the full 6%.
I believe so.
Okay.
We were still in the state was still in the red.
Yeah, and the Cameron Wood or Commissioner Harrington, they know better than I do, just in terms of the background.
The corollary to that is, the state of Vermont acted very responsibly in fixing the problem, but we also heard rumors that other states, just with huge debt in their funds in the red, sort of just shrugged their shoulders. And I'm wondering if they paid a price for that, or the federal government never really enforced that, or would not fully enforced it. And I don't know if you could find that history out.
I can certainly look into it for the next meeting.
Okay.
But yeah, it's not something that I know.
Can I just ask the dumb question? So the default rate for businesses then, if all is going well, is 0.6%. Is that how the math sugar, the effective rate? I guess?
Right. If we're in conformance, the effective federal rate is 0.6%.
And is there and that's the rate the businesses pay, or there's a state kit on top of that?
Yeah, so the state tax on top of that can range from, it's going to depend on which tax schedule we're on. And then within the tax schedule, there's rate class 0, which is for folks who have had no separations that have collected benefits, all the way up to rate class 20, which is for folks who have the worst unemployment experience, the most people laid off and the most benefits paid out. And those rates will vary greatly across that range. When we look at, again, later this morning, we're going to just look at our tax schedules next to Rhode Island's tax schedules, just as an example of two different sorts of arrays of tax schedules. And the point is not to say that one is better or worse, because Rhode Island has a different funding model than we do, but it's to give us a better sense of sort of how those taxes move as you go from schedule to schedule, and the potential for what's often referred to as smoothing tax increases if you add additional schedules in the middle. So instead of a 0.4% jump, you have a 0.2% jump because you added additional steps. But we'll get to that later this morning.
Right now, we're trying to focus on what the federal limits of our powers are, or even the federal supports for our powers.
Right. So the big thing is the federal government wants to see us maintain a solvent trust fund that doesn't need to borrow in a recession. So they don't have specific requirements around the balance. There are a number of requirements for how we run the program. There are requirements for what we can use trust funds monies for. There are requirements around how we administer it. And then if we do get into a borrowing scenario, having a well-administered trust fund has an impact on what the state is going to experience. In addition, the department may be able to add additional context from some of the background things that they experience in terms of benefits accuracy management and other sort of controls on the trust fund that they need to implement, basically to ensure that money is being used appropriately under the federal guidelines, but that doesn't directly go to what's the base amount we need in the trust fund. So it's up to us to determine what a good solvency rate is. This is a guideline the federal government uses. Like I said before, Joyce or Matt Barowitz or Commissioner Harrington may all have opinions as to whether it's adequate or appropriate. And that I'm not an economist or an administrator, and I can't speak to that. It's simply what the federal government provides as a guideline. All right. So Vermont's tax rate is annually determined by dividing the state's current fund ratio by its highest benefit cost rate. So these are two fairly loaded terms. So the current fund ratio is determined by dividing the available balance of the unemployment compensation fund at the end of the preceding calendar year by the total wages paid for employment, as that term is defined within the unemployment statutes during the calendar year as reported by employers by the following March 31st. So what it's basically looking at is what was the available balance in the trust fund versus the actual wages that were paid to individuals who are potentially eligible for unemployment. So that's the first thing. We're looking at how the trust fund compares to the pool of workers and the wages going out. The second piece is the highest benefit cost rate, and we talked about this a little bit earlier. This is the highest amount of benefit payments made during a consecutive 12-month period in the last 10 calendar years. So it's our worst recession year in the last 10 years by the total wages paid during the 4 calendar quarter periods that ended within that 12-month period. So that's a complicated way of saying what was the total reported wages during that time, because wages, if you remember, reported at the end of each quarter. So that 12-month period for benefits may not line up perfectly with calendar quarters. But essentially what we're looking at when we do this is we're saying, what is the ratio of the current status of the fund to what the benefits versus wages in our worst year in the last 10 years. And that gives us a ratio. And the ratios give us our tax schedule. So if you get to a current fund, or if you get to a ratio of 2.5 or above, you go to the lowest tax schedule. Conversely, if your ratio is under 1, you go to the highest tax schedule. And what's been described at times as sort of the midpoint or equilibrium point here is the tax schedule 3, the 1.5 to 1.99 ratio. So each ratio there is a jump of 0.5. And what this is basically looking at is, let's take our worst year in the last 10. And so if we're under the amount that was necessary in the worst year in the last 10, we need to raise taxes as high as they can go to replenish the trust fund. If we're at 1.5 to 1.99, we kind of hit that midpoint. If we're at 2.5 or above, we can drop taxes to the absolute lowest point. And then there are steps in the middle. So this kind of gives you a sense of what our current model is doing here. And this is one piece of the puzzle here. There's also the taxable wage base, which is currently 14,100. Vermont is in a good place because our wage base is indexed for inflation. The one interesting aspect of our wage base is that currently we have a permanent provision that anytime we drop to Schedule 3 or Schedule 1, that wage base is reduced by $2,000. So we kind of take a step back on the wage base, and it helps, it increases the reduction in taxes, but it also reduces the pool that you can tax to draw funds from for the trust fund. So, and just to be clear, I'm not saying this is good or bad. It's just putting this out there as factors that are influencing how our trust fund is currently financed. And there are things you may want to consider looking more closely at or adjusting as we move forward. So before I move on to benefits, are there other financing questions?
Can you explain the drop 2,000 again?
Sure. So anytime we drop to Schedule 3 or Schedule 1, so the taxable wage base normally each year it increases by the percentage increase in the state average weekly wage. But what happens when we drop to Schedule 3 is, so in the most recent instance, we were at 16,100. We dropped to Schedule 1 and our taxable wage base dropped down to 14,100. And then it will start indexing from there. So it's kind of a reset that brings it down $2,000 when we get to one of those tax rate triggers. And so what that does is it means not only are your tax rates dropping, but the pool of money that an employer has to pay taxes on is also shrinking. So it's helpful for employers. It reduces the tax burden, but it may also limit the amount or the ability of the trust fund to generate revenue at that point. So, so that's something there where there's both pros and cons to that potentially. The other piece of this is the indexing, which is good because it means that the wage base that you're taxing doesn't erode over time as we see inflation, because we're taxing it to wage or indexing it to wage growth. So that is typically considered a good thing because it means that you're not going to get 10 years down the road and have a trust fund that was at one point very healthy, but now can no longer keep up because inflation has increased benefit amounts, et cetera, but your tax base is shrinking.
Thanks.
Like where we were in 2009.
Right. So these were reactions to the situation before the Great Recession, where Vermont had gone through years of shrinking revenues. Even though we weren't in a recession, we were seeing increasing pressure on the trust fund, which is what drove the fund into the red when the recession started. So these were responses to that. I think the question before this panel is, were those responses too strong or were they appropriate? Or do they need to be adjusted going forward? Are there things that need to be fixed or tweaked? Okay, other questions?
So the three things that drive the taxes, it's this chart,
Mhm.
taxable wage base, and the experience rating of an individual employer. Is there anything else out there that impacts what an employer pays?
So those are the other piece is just going to be the employer's payroll. So, you know, and that's just, if you expand the number of employees you have, you're going to be paying taxes on a larger base, but assuming your number of employees stays the same from year to year, the things that are driving it are your experience rating, the tax schedule, and the taxable wage base. Those are the three pieces.
Do you have a chart of the experience ratings that you're going to put up there as well?
I meant to give the committee the chart I prepared this past session. I'll give that to Mike at the break to post. I will go over a very simplified chart with just the low, medium, and high rates for Vermont and Rhode Island later this morning, but I will get the committee the chart with all 21 tax classes and the 5 different rate schedules. Anything else? Okay.
Well, where are we now what's our schedule today?
So I think we're going to 10:30. Is that right, Madam Chair?
Our tax.
The tax schedule.
Tax schedule. That is a good question, Commissioner.
I believe, to your point about looking at the past 10 years.
Commissioner, I'm sorry, but with the Zoom and the mics and the things, maybe you can tell Damien and then Damien could repeat what you said.
I believe what we did last year was looking at the last 2 years in the past 10 years, which held us out of Schedule 5, and we only went to Schedule 3.
Okay, yeah, so the Commissioner just relayed that he believes we're at Schedule 3 right now because of the legislation where we took 2020 out of the last 10-year look back. And so that mitigated the impact on the trust fund, because otherwise we were going to Schedule 5.
Thank you.
Okay, so unemployment insurance benefits. So again, this is an area where the federal law does not require a specific benefit rate or establish a minimum or maximum benefit rate. And I have included in the documents posted on the committee's webpage a 50-state plus DC look at benefit rates. How is the benefit calculated? Just the very basic formula. What's the minimum? What's the maximum? And is there a dependent allowance? And what you'll see with that is benefit rates vary greatly. One thing I will say about that chart is, with the exception of Vermont, some of the benefit rates, the information dates back to January 1st, and some states index their benefit rates on July 1 like Vermont does. So some of those benefit, the minimum and maximum amounts may have changed. But the formula should be the same unless there was a legislative change this year. And that was just a function of time there. So the federal law does require the payment of UI benefits to certain types of employees, such as the employees of state and local governments, federally recognized Indian tribes, and nonprofit organizations with 4 or more employees. And then other states, there are other restrictions on employment, such as for small agricultural operations and so forth. But what it comes down to with the federal government is they're saying you have to cover these people in this way, or these people should not be eligible for benefits. They're not saying you have to provide X dollars worth of benefits. So for our question of, is the benefit amount appropriate? The federal government's guidelines are essentially silent on that issue. They're more concerned with who you provide benefits to and whether they're getting benefits in the same manner as other eligible employees, which is one of the requirements, for example, the employees of nonprofit organizations that are reimbursing the fund, they're eligible for benefits in exactly the same way as someone who works for a regular contributing employer.
So the federal exemptions, are they permissions to exempt or are they mandates to exempt, say, farm workers?
So it varies. So a good example of a shall not include is school employees during the summer break between school years when they're returning for work. But then there are certain types of school employees that a state may exclude or choose not to. And those are, for example, bus drivers, I believe is a good example of that. And I'm going off my memory here, so I apologize if I may not be 100% accurate, but for example, teaching staff are excluded. That's a shall. Bus drivers are a may. Vermont has elected to exclude them in its UI tax law, but it's not required to under the federal law. With the employees of nonprofit organizations, the federal law says you shall cover nonprofit organizations with 4 or more. 3 or less is up to the state. Some states have covered them. We do not. So those are instances there where with these particular points for the federal government, each one is a little bit nitty gritty, and it varies. And so that's something where if there is a particular group that you're curious about, we can have a conversation offline and discuss what the federal requirements are versus what our state law provides.
I was hoping there was an overarching systemic thinking, but of course
there isn't.
Okay.
No, I think like so many things, I think these have developed over time. And as you know, Congress adds to the list of requirements or permissions for state governments on this as things evolve. So this is a system that's a little over 80 years old, and it's definitely evolved over time in multiple ways. And oftentimes little things change and the rest of the system kind of stays in place and you're left with a somewhat confusing picture.
Thanks.
As things move. So if we go to Vermont's requirements now. So weekly benefit amounts are determined by dividing the 2 high quarter total wages by 45, provided that the weekly benefit amount that you get by doing that doesn't exceed the maximum amount set in subsection F. This works out to about 57.8% of an individual's wages during their 2 high quarters in their base period. Just a quick refresher, a base period is typically it's either the first 4 of the last 5 completed calendar quarters. If you don't qualify under that, you look at the last 4 of the last 5 completed calendar quarters. And then I can't remember, I think the third option is you look at the partially completed calendar quarter and the 3 after that. But I can't remember exactly if that's it. And there is also an alternate. If you were injured when you first became unemployed, there's an alternate mode for determining eligibility then. But the way it works is the department will look first at option 1, then option 2, then option 3 to try to qualify you for unemployment benefits. If you qualify, they look at your 2 high quarter wages, and then they divide those by 45. So you get about 57.8% of your wages, provided you don't exceed the max benefit, which is 57% of the state average weekly wage. There was, as you all know, a $25 additional benefit that was set to take effect on October 6th. We're going to discuss that in much more detail later today, so I'm not going to touch on that. It has been determined to be out of conformance, so that will not be affecting our benefit rates. As I mentioned, though, the 57% of the state average weekly wage is the cap. And I believe that is currently $631, but I will touch on that later today when we start comparing between states.
And is
So-
there a minimum?
The minimum, there is not an express minimum in statute. There is an effective minimum, which is on the chart, the benefit chart that I provided, and that basically works out to what's the minimum benefit that you could get if you qualify for UI, because you have to have a certain level of connection to the workforce to qualify. So you need a certain amount of wages in your highest quarter, and then you need to earn at least 40% of that in the remaining 3 quarters in your base period. And if you look at that amount, your minimum comes out to what we've got in the chart there. And that's what you'll see for a lot of the states is there's a minimum, but it's not necessarily set out in statute. A handful of states do say the minimum benefit is, $25. I'm just throwing out a round number, but they'll say that in statute. But in most cases, it's what's the absolute minimum amount I could earn and still qualify for benefits, and what weekly benefit would that give me? Are there questions about benefits?
So is the 57.8% essentially 26 divided by 45?
Essentially, yeah. So if you assume 26 weeks there of wages divided by 45, but the 45.
That's in statute.
That's in statute. So dividing those 2 high quarters by 45 gives you about 57.8% of the wages. If you took your 2 high quarters and turned that into 26 equal weekly amounts, understanding that some people might earn $200 one week, $150 the next, and a different number each week because their hours vary. If you averaged their wages out so each week was equal, they would be getting about 57.8% of that average weekly amount that they earn in their 2 high quarters.
When we were talking about paid family leave and workers' compensation, things like that, it seems like the wage replacement was much higher than for unemployment benefits. In your reading or understanding, is there any theory behind why the unemployed people get less than somebody out on a work injury or somebody out for childcare?
So I think there are a couple of theories behind that. And there's some historical context too. So my understanding is historically, wage replacement started out around 50% when the unemployment insurance system was first starting. Most states started out around 50%. Now, the majority of states appear to be at or above 50%. A lot of states are in the 50 to 52% range. One of the theories behind keeping the benefits down at that level, and we've heard this talked about in the press a lot in the last 9 months in particular, is it encourages people to make a meaningful work search to get back to work because the benefits are not very generous necessarily. But I think some of it's history, some of it's concern about people not wanting to get back to work. There are a lot of questions that have been raised about whether that's actually true. And that's stuff that I'm not qualified to answer. But those are the 2 sort of reasons that I know for that. And I think that from my understanding, might contrast to someone who has a work-related injury. And once they're done healing, they're ready to go back to work, same as if you take family leave. It's the idea is that you've got X number of weeks, so your workers' comp runs until you reach end result. Whether your doctor determines that you've healed as much as you're going to heal, and at that point you need to make a determination of, is there a permanent partial or total disability, or with family leave, you have 12 weeks and that's it. At that point, you either go back to work or your employer can lay you off. So there are some differences in the way the systems work. Again, the sort of anecdotal reasons for driving people back to work, I can't say if that's more valid in the unemployment insurance context than the workers' compensation context, and I am not aware of evidence that specifically supports either side other than anecdotal evidence, which I've heard on both sides of the argument. But that's my understanding of sort of the background.
What year did the unemployment insurance system?
1938, I believe.
Thank you.
This is part of the New Deal.
Any other questions before we?
Okay. So we're going to move on to the period of disqualification for fraud, which is also known as a knowing or intentional misrepresentation or omission of a material fact in your claim. In other words, you intentionally do not let the department know that you're earning $200 a week at a part-time job, which might qualify you for partial unemployment, but not full unemployment, and you receive additional unemployment because of that. So the federal law specifically permits states to deny UI benefits on the basis of three things: discharge for misconduct connected with work, fraud in connection with a claim for compensation, and receipt of disqualifying income. So the fraud is the one that we're going to be addressing. And then the one requirement that the federal government provides here, very specifically here, is that all states are required to assess a penalty of 15% of the amount of the overpayment against a claimant who received the benefits because of fraud. So this is in addition. You take, let's say I received $100 in an overpayment. The state, once it makes the finding that I received that because of fraud, they have to assess the $15 penalty.
Do we get the $100 back too?
Yes, the state is expected to seek to reclaim the $100. There are multiple mechanisms for recovering overpayments, offset of benefits, civil claims, potentially offsetting tax refunds. And then the states and the federal government also work together, where if you have an overpayment from another state, it can potentially be deducted from your benefits. Say I get an overpayment here in Vermont and then move to Massachusetts and file an unemployment insurance claim there. My overpayment in Vermont could be deducted from my Massachusetts benefits and then sent to Vermont to pay that overpayment.
So the state is required to both get the overpayment back and assess a penalty. And we may deny benefits, but we're not required to deny benefits.
Right. And
Can I ask one more question?
Yeah.
For you to pile into that pile of questions? And that's only with overpayment that's specific to fraud? Or is that all overpayment?
Yeah, no, that's overpayment specific to fraud. Same with receipt of disqualifying income, or, if I was fired for, say, stealing my job, the state can disqualify me for benefits. So those are the three reasons why a state can outright deny UI benefits. And it's worth saying at this point that the way states deal with fraud, there are 50 states and essentially 50 different ways that they address fraud. There are some common themes. A lot of states have a criminal penalty for it. It varies from state to state, whether it's a misdemeanor or a felony. In some cases, it depends on the amount that you received fraudulently. Small amounts can be a minor misdemeanor. Larger amounts can be a felony. Some states provide for civil recovery. Other states provide a period of disqualification. The periods of disqualification vary from state to state. Sometimes they're related to the amount you received versus your weekly benefit amount. Other times it's a specific calendar period, such as 52 weeks from the fraud plus the next benefit year, something like that. In our case, you're disqualified for a certain number of weeks, depending on the number of weeks of fraud you've committed, up to 26 weeks, which is the amount of benefits you're entitled to. And that stays with you. So as I think all of you will remember from early in the pandemic, there were individuals who'd been determined to have defrauded the unemployment system several years ago and then got laid off for the first time since then, filed a claim and had a multi-week disqualification, in some case up to 26 weeks facing them. So they essentially couldn't get the benefits, and because they weren't eligible to get benefits, they weren't eligible for the additional federal supplements and so forth. So with the moving on to the benefit overpayments, which is the other side of this here. So you have both fraudulent overpayments and non-fraud overpayments. This can be through mistake, an error on the department's part, an employer who didn't reply to the department's questionnaire. This happens sometimes where an employer is asked, to confirm information related to the separation and doesn't return that information to the department in time. So the department pays out benefits, and it's only later that the employer says, well, actually, they shouldn't have received benefits because of this reason. So the federal law does require deductions from unemployment benefits to repay the benefit overpayments. And it also requires states to deduct from unemployment benefits an amount equal to the overpayment from another, whether it's the federal unemployment programs or another state's unemployment program, in the same manner as it does its own states. The deductions, again, vary. So some states do 100%, some states do 50%. And that's something that we have some leeway there, but the bottom line is we have to be doing deductions to repay overpayments. The one caveat to this is the states may provide for a waiver of recovery of overpayments, and federal DOL has previously encouraged states to adopt policies that permit the waiver of non-fault overpayments when recovery of those overpayments would be contrary to equity and good conscience. And so that is obviously not a black line, kind of clear line there, but it does provide discretion to the department to determine when recovery of an overpayment should be waived. There's that sort of equity and good conscience test that's provided. Vermont statute, as we're going to discuss, doesn't specifically provide that sort of discretion. The department can address instances and when it may be or may not be providing waivers. I don't know if they are at this point. And I don't know enough about that, so I would leave that to them. But I think one of the issues that we were discussing in the session was, should we provide discretionary authority for the commissioner to revisit the overpayment, or for someone to apply at a later date and say, I'm experiencing economic hardship, I desperately need benefits, this was a non-fault overpayment, I'm seeking a waiver because of that, because it was it was a mistake, or the employer didn't return the form in time, and now I'm unemployed and unable to get benefits, and this is an economic hardship.
And so that's perfectly permitted under federal law. Yes?
Yes.
Okay. And then in the case of fraud-based overpayments, the repayment of the overpayment, did I hear you right, that can happen sort of as slowly as we determine at whatever percentage, as long as it's happening?
So I don't know if there's a minimum percentage. I know that still some states have set a percentage below 100%. So they're taking 50% of the weekly benefit. So people still can receive benefits after they've finished their period of disqualification, if the state imposes one of those. So
We don't need to have a period of disqualification under federal law.
You don't, you can, but you don't have to have that period. I would say that the states that don't have a period of disqualification usually provide for criminal prosecution. And we used to have a criminal prosecution statute that we got rid of a little over 10 years ago at this point, or about 10 years ago. So that's just something to keep in mind. The questions with that, a lot of those are going to be operational questions. We're a small state with limited resources. What is enforceable and what makes sense? I think some of the questions for you are going to be, does our current period of disqualification make sense? Does it make sense to have it time limited? Does it make sense to provide authority for the commissioner to waive overpayments in certain circumstances? So the non-fault overpayments, this would, if you limited it to non-fault overpayments, and in an instance where an individual had gotten those benefits by fraud, they still wouldn't be able to get the overpayment waived. But you could also say recovery is capped at 75% of the weekly benefit, in which case those individuals would be able to receive something, or some other amount. So our statute on periods of disqualification provides that when the commissioner finds that a person intentionally misrepresented or failed to disclose a material fact with respect to their claim, and in the event they're not prosecuted under section 1368, the person shall be disqualified and shall not be entitled to receive benefits to which he or she would otherwise be entitled after determination for a number of weeks not exceeding 26, as the commissioner deems just. And the way that the number of weeks is determined is set by rule. I believe on your first fraud, it is 1 week per week of fraud. So.
But Damien, the way I read this is that if the department doesn't prosecute under 1368, then fallback is this disqualification. So.
Right. So I'm going to stop my share here just to pull up 1368 because I believe that this is one of those issues where I believe 1368 is not really used. So 1368, 1368 says a person shall not willfully and intentionally make a false statement or representation to obtain or increase any benefit or other payment under this chapter for himself, herself, or any other person. And then 1373 provides a general civil penalty A person who violates a provision of this chapter or any lawful rule or regulation of the board for which no other penalty is provided shall be assessed an administrative penalty of not more than $5,000. So what this basically says is that the alternative here is to assess an administrative penalty of $5,000, and in either case, the department is going to be required to recoup those benefits and assess the 15% penalty. And so my understanding is the department by default just imposes the period of disqualification, and 1368 is not really used for this. I would defer to the department though to correct my understanding if I'm wrong on that, and they can speak to that more. About 10 years ago, we had other provisions in the statute, and it was 2009 number 142, I believe, that made the amendments to this and got rid of the potential criminal penalty for the fraudulent misrepresentation that we used to have in the statute. This is long before my time here, so I don't know. I don't know the background to why we got rid of that, whether it was that it was not being used, that we had insufficient resources, that the General Assembly determined that a criminal penalty wasn't appropriate for this kind of fraud. And I would defer to folks who were here then and might have a better recollection of that debate.
So conceivably, someone, if the department's using that as the default, the penalty weeks, someone could pay more than $5,000.
Yeah, so the department
And the penalty in statute is up to 5,000. So
the
they're-
penalty is up to
so
$5,000.
they have the commissioner has to make a determination on what the penalty would be.
The penalty is up to $5,000, but you still need to repay the
Right.
overpayment, and you need to, the department has to assess that 15% penalty. We're not limited to just the 15% penalty, but we have to assess a floor 15% penalty. That's the floor. A number of states actually assess a higher penalty and then they separate the money so that the 15% is paid in the way the federal statute requires, and the remainder goes to, for example, an enforcement fund or something like that to essentially fund the enforcement efforts of the department.
So my recollection is that during the pandemic, the beginnings of the pandemic, we had people that were serving penalty weeks that had paid back the amount of overpayment, but weren't charged a penalty, and now they were on penalty weeks.
Right.
And so, I mean, that just goes way further than a $5,000 maximum penalty.
Right. So, and this is one of the things that is a question for this committee to consider is using the disqualification appropriate? If it is, would it be appropriate to implement something like a cap on how long that disqualification can stay in place? For example, 2 years or 4 years. And then after that, it's off your record and you can make claims again. And if you do make a claim in that period of time, then you have to serve the weeks of disqualification before you can qualify for a benefit. So that's one option. The other option is to say, we're going to look at an alternative deterrent penalty here and see if maybe instead of disqualification, criminal prosecution for severe fraud is more appropriate, or pursuing this administrative penalty or assessing a higher penalty amount on the overpayment. And that varies greatly from state to state.
But you could also cap the amount of the disqualification so that it's not a total disqualification every week. So that
That's right.
they could at least receive some remuneration while they're still searching for a job. And I think the big issue for me anyway, was that these people that were disqualified, totally disqualified, couldn't go out and find a job because everything was shut down. So you have people that don't have a job, lost their job through no fault of their own. And then were out of luck for any type of money coming in to sustain themselves and their family. So I think that's where we've fallen through the cracks, and I think that's why we're talking about this now. So.
Yeah, and it's important too to distinguish between a period of disqualification when you're not eligible, and then the recoupment of benefits when you're filing an eligible claim. That claim is being reduced by the amount that you owe up to 100% potentially.
And again, it's just the recoupment that we're required to do federally.
Right, we're required to recoup those benefits. And we are required to assess at least the 15% penalty amount.
Can you bring your screen back up? Because I have a
I
question
can,
about the
yeah.
language, if you were.
Yep, I'm good, thank you.
So
That sentence, that a person intentionally misrepresented or failed to disclose, does the intentionally also apply to the failed to disclose, or does it just apply to the misrepresented?
as I read it, it's meant to apply to both.
Thank you.
So that's what makes fraud is that it was an intentional misrepresentation or omission. If there are others who think that the language needs to be clarified, then I would, certainly.
I'd like to hold that idea to ask the department at a future date, if you could help me hold that specific question.
Sure.
Thanks. And then my other question is, if an employer intentionally misrepresents or fails to disclose a material fact, is there a separate area of statute for that I haven't spent time looking at that we should look at
There
right
are
now?
separate penalties for employers. This is when we get into employee misclassification.
Great.
Which is.
Something we're not going to talk about.
That's right.
Exactly.
Thanks so much.
It's the,
All your rule.
yeah. It is another big issue hanging out there, but it's being looked at by the other groups, and I imagine we'll all be talking about it again when the session starts.
Probably you more than me.
Great.
Thanks.
Hold on a sec, let me restart my screen sharing froze here, so let me restart. Try that again. Sorry, I'm just going to page through here. Unfortunately, the toolbar for Zoom blocks out my toolbar for PowerPoint. All right. Okay. Okay, so here we are. So the other piece here is that we just don't provide anything in our law for a waiver or reduction of a period of disqualification after the determination becomes final. And what I mean by that is after the appeal period is run. Up until then, you have the opportunity to appeal your disqualification and say this wasn't fraud. But after that appeal period is run and becomes a final determination, then it's stuck. And I think many of you will remember testimony again from early in the pandemic about people who didn't exercise their appeal rights, whether it was because they didn't understand what was happening, or it didn't seem important at the time, or there was poor communication, any number of issues that they didn't exercise their appeal rights. And then when they filed their claim for benefits, they became aware that they were disqualified for fraud and didn't realize or weren't aware that they couldn't get that disqualification removed
And so are there federal rules about that appeal period or reopening the appeal or?
So the federal law provides that we have to provide a reasonable opportunity for appeal. And that opportunity varies by states. We have multiple steps in the appeal process here in our law, which would reflect sort of the more generous appeal options offered in other states. The concerns here, I think, that have been expressed are not so much about the appeal period, although there were concerns about whether it's too short a time frame, but more about whether people were aware of what rights they were potentially waiving by not exercising their appeal. That I think is kind of the big question there. There may be some questions about, for example, how do we better communicate or educate people about what their rights are here? Is the timing for the appeal appropriate in this case? And then the bigger question that's in the charge for this committee is, should we be doing something about the actual disqualification to allow some discretion or allow it to be waived after a certain period? And that's really, I think, one of the tough questions there. As we'll see when I go to the other states later on, I have not had a chance to look at all 50 states. But the states I was able to look at on this, in general, they did not allow for a discretionary waiver after the appeal, but a number of them did allow for that disqualification to lapse after a certain period of time had passed. And that's one of the distinguishing features.
So, but it is possible that we could provide a waiver at the time of someone applying for benefits and finding out that they've been disqualified.
Yes, I think so. I wasn't able to find anything that would say we can't do that. I also wasn't able to find examples of it. I know early on in the pandemic, there were constituents who raised examples from other states. I went and looked at those statutes and wasn't able to find the language that was referenced. It's not to say it's not out there, it just wasn't in the cited statute. So this is something where I just ran out of time to fully examine all 50 states on this issue and find examples, but it is possible that we could provide for some sort of waiver of that disqualification. The big thing for this is recovering the overpaid amounts and assessing that penalty. Then the next question is what's an appropriate deterrent? And there is Cameron Wood from the department was nice enough to loan me an up-to-date summary of highlights from some state laws. There is an extensive summary at the end of this booklet here of the various penalties for fraudulent claims that are imposed in other states, with pages of footnotes that I can make photocopies of and provide to the committee to give you a sense of just what's out there for the penalties.
Mm-hmm.
And this is more up to date than the US DOL's resources on this. So that's something that might give you some sense of whether, if you're deciding to move away from disqualification, but looking for something that still deters people from making fraudulent claims, what are other ways we can approach that?
I wonder if as you're combing through other states, if there are also just states that kind of, in a more blanketed way, give their commissioners, some discretion, so that it looks on statute like they have kind of firm disqualifications or whatever, but then, at the end of it, the commissioner would have the right to use their discretion.
Yeah.
We see that in tax stuff like that. So I don't know, it seems to me it might be a way to go, and I'd be curious if there are others that do that.
What I did find was express discretion in relation to overpayments that were non-fault. I didn't find similar language related to fraudulent overpayments and fraudulent claims. But it's something that we could look into, and certainly there's the possibility of kind of providing general discretion. The tricky thing with provisions of general discretion is that you do run into potential issues if it doesn't have any sort of guideposts around it. So that's just something to keep in mind. And the panel or the General Assembly might want to, if they do establish discretion, kind of establish something with some specific guideposts, like, you know, after X period of time, the commissioner can waive the remaining period of disqualification for when conscience, good equity and good conscience dictate.
I also think it's helpful to think that commissioner discretion can be a shall and not a may, with guideposts. And I'm hoping that we can go back to just the Vermont landscape and the federal landscape so that we can take a break.
Mm-hmm. Yes, we're coming right up. And the way, I'm trying to think, I only have a few slides left.
That's what I was thinking.
So let me get through these and then. Okay, so getting on to overpayments. So the overpayment provision is, and I've bolded here, irrespective of whether the non-disclosure or misrepresentation was known or fraudulent. And so this gets into instances when someone has received an amount of benefits because they didn't realize that they were required to report certain information, or they misreported the information and it was an honest mistake. It wasn't an intentional misrepresentation. And then the language goes on to say, you know, while any conditions for the receipt of benefits were not fulfilled or they were disqualified from receiving benefits. And basically this provides that they're liable to repay that amount to the department. And then that's the language there in 1347C. And then our language currently provides the commissioner may withhold in whole or in part any future benefits payable to such person and credit the withheld benefits against the amount due. This is language that the panel may want to look at, providing a specification as to how much is withheld. And some states do that. Giving it discretion here, I think this is basically dictated by rule at the department. And my understanding, and I'll let the department correct me if I'm wrong, is that we withhold 100% until it's repaid. And so that, again, this is an area where there's potential to adjust that. And this would address the situations of individuals, you know, at least receiving something while they're searching for work, especially if you're in the middle of a large recession and there are no jobs available. Okay, so federal legal background on reimbursable employers. And this is going to be a classic example of federal legislative drafting. The first provision is 26 USC 3303E, which says a state may, without being deemed to violate the standards, permit an organization described in section 501c3, basically a nonprofit tax exempt organization, to elect to pay, to reimburse the state unemployment fund in lieu of paying contributions. That's paraphrasing the very lengthy sentence there. But then if you go to 42 USC 3309A, it actually requires the states to permit local governments, federally recognized Indian tribes, and nonprofit organizations who would otherwise be liable for contributions to reimburse the state's trust fund for benefits in lieu of paying those contributions. And this is a classic issue with the UI legislation at the federal level. In some instances, it says may, and then it was changed to a shall later on. And it's also split between the Internal Revenue Code and the Social Security Code. So you're stuck with the provisions of the law being split into two different titles of the federal code and sometimes appearing to conflict with each other. But the bottom line is that we have to permit nonprofit organizations to reimburse, provided they're covered, they have 4 or more employees. We don't have to provide coverage if they have less than 4 employees. Some states elect to do that.
And there's no notice provision for those employees.
There's no notice
or
provision
less
in our
category.
state law. Some states do require notice, but our state law does not.
And is there a timeline? I mean, is it a direct hit over the next 3 years or, you know?
That's a great segue. So under our law, you can elect to become a reimbursable employer for a period of not less than 12 months. You continue to be liable for payments in lieu of contributions until you file a written notice terminating the election or the commissioner terminates it for you because you're not paying your reimbursements. And then if you've been paying contributions, you can also change to a reimbursable basis. Oops, sorry, wrong button. And then getting to your question here, under our system, at the end of each calendar quarter, or another period determined by the commissioner, but in our case, calendar quarter, the commissioner bills the nonprofit organization, and then they have to pay that amount within a specified period of time. They do have the option to request permission to pay by getting a quarterly bill based on the costs that were attributable to them in the prior calendar year. And then what happens is, or a predetermined percentage that the commissioner figures out if they are a new nonprofit that didn't pay contributions or didn't have benefits attributable to them. Commissioner can modify that amount each quarter. So if your experience is trending badly, the commissioner could say, you were paying 1%, you're going to pay 2% now. And then finally, at the end of the year, and this is true across all states, there is a true up. So if you get to the end of the year and you've paid less than you actually had in terms of attributable benefits, you have to pay the extra amount. You get billed for that. And if you've overpaid, you can either use it as a credit for the coming year, or you can get a refund from the department. I do not know the extent to which nonprofit organizations are aware of or take advantage of this provision. That would be a good question for the department. The method that I'm most familiar with is the quarterly bill, where you then pay that quarterly bill within a certain period of time. As you'll see, if you look at the handout I provided on reimbursable employers across 50 states, every state has a periodic billing provision. Only some states have this alternative option where you can pay this sort of predetermined percentage of your payroll and then true up at the end of the year. In addition, a lot of states, but not Vermont, have either an optional or a mandatory bond requirement where you deposit with the department or with an organization that provides bonds, surety bonds, basically a bond that's against your potential liability, so that if you are out of money because you didn't budget for layoffs that year, they can then draw on the bond to pay those benefits. There is one other sort of variation on that model that is interesting, and that's where essentially the state holds an account for the nonprofit at a certain percentage of their payroll, and they draw down that account and then bill the nonprofit to refill it to that percentage, so that the state's always holding money to pay the benefits. And then they're billing the nonprofit to basically replenish the account. And that provides some insurance on the benefit payment side that the trust fund is going to be made whole. The downside for the nonprofit is they may be putting money into the UI trust funds or into this account to pay UI benefits that they don't have. One of the benefits of being reimbursable is that if you have good unemployment experience, you have no costs here. And so that's one of the potential pieces here. So there is some ability to play with the reimbursable model. Potentially a bigger factor in this is how liability is allocated, because one of the issues that was brought to the General Assembly's attention was this issue where, because we bill for benefits attributable to the employers in the base period, so we look at basically what proportion of the claimant's wages did you pay in their base period. So say my nonprofit organization employed this individual through the 4 quarters in their base period, and we were their sole employer. We're responsible for 100% of their benefits. At the end of their base period, they left employment with me and took a higher paying job in the private sector at a company that then downsized them 2 months later. Now I'm paying the benefits, but I am not the person who actually is responsible for their unemployment. So, and that's the way it works in our system. You're liable for all of the regular benefits that are attributable to you in the base period based on the proportion of wages that you paid for that claimant in the base period, and 1/2 of the extended benefits, because that's split with the federal government.
And I am looking for nonprofit employers who have any interest in this issue. And so if anyone knows anyone or have ideas about knowing anyone, the department is helping with that search. But I think that would be very helpful to get our heads around this, is to have some of the impacted employers and employees at the table.
Yeah. And so the big thing to note here in Vermont, we are one of many states. I think the majority of states, I think it's like 34 states plus the District of Columbia, allocate based on the proportion of base period wages. The alternative option, which we're going to discuss later this morning, would be to allocate to the most recent employer or an inverse order of employment. But as with many of these other changes, one of the big questions is, can our system do a systemic change like that now? Or is that something that we're going to have issues with because of the antiquated IT system that we have? The other thing too is, what are the unintended impacts of a systemic change in how you bill benefits? So I'm putting this out there as something that could impact us, but there are a lot of unanswered questions and potentially unanticipated impacts from that.
Does this chargeability apply to all employers or just reimbursable
It
employers?
applies to all employers. So
It's the reimbursable employers a lot harder because they're a self-insured group rather than a socially insured.
that's right. So if I'm a private employer, it means my tax rates go up. So it can hit a small business equally hard to a small nonprofit, because you can see a massive hike in your unemployment insurance tax rate, even though you weren't responsible for the layoff. But by the same token, if I was the business responsible for the layoff and I have a small payroll and a small budget, I could still see a massive spike in my unemployment tax rate because I have such a small payroll to benefit experience ratio that getting that experience from just a single layoff can spike my unemployment taxes. So I think one of the things to just keep in mind with this is that there is a push and a pull on all of these things, and there probably isn't a perfect answer. But there are potential things for us to explore.
So has there been is there any information or any studies that show that reimbursable employers do better than if they join in the pool? I assume they make the choice themselves, so they weigh the projection of layoffs and things like that and say it's going to be cheaper for me to go it alone rather than pay insurance. But has there been any, like, whether that works out or not?
I'm not aware of any studies. There may have been, I'm just not aware. I know anecdotally, one thing I did find doing research on this is in some states, you could find, if there was a recent change in the tax structure, they would say, nonprofit groups would say, you may want to consider switching to reimbursable now, because now it's a better deal than paying contributions was under the old tax structure. But I can't speak to whether broadly that works
I
out.
think Senator Pearson had a question.
I'm just trying to understand which employers are eligible to be a reimbursable, because is it just nonprofits, or does that also extend to local governments and
The state is a reimbursable employer. Local governments are eligible to become reimbursable. And nonprofit employers eligible to become reimbursable. If we had federally recognized Indian tribes in the state, they would also be eligible.
so schools would be local government in this case?
Yes.
Okay, thanks.
Yep.
Oh, one last question. During the pandemic, there was some relief to paying your reimbursable bill. What happened there? At one point, it was like 50%, and then did it go to 100%? What's the status now?
What I can recall on that is that it started out at 50%. Initially, the initial guidance was reimbursables had to pay their reimbursement, and then they would get reimbursed themselves for 50%. And I think that changed to a 50% offset. I think Cameron would probably be better to answer what happened with that. I don't know much beyond the initial legislation. I know that there was further legislation on it, but it just wasn't something that I focused on this past year.
So it'd just be interesting to know how much the trust fund took at a hit as a result of that. What do the feds reimburse dollar for dollar, whatever the?
Yeah, I mean, I think the trust fund probably didn't take a hit, but I think it would be a question for the department, what was the amount that reimbursable employers paid and versus the feds, and did they experience significant issues with reimbursable employers being able to pay the reimbursements as they came in?
Okay.
And Joyce is going to do some work to figure out the scale of nonprofits that we even have as part of this conversation.
The last piece I would just note here as the background is multiple reimbursable employers can establish a group account where they basically agree among themselves to share the costs. I don't know how often this occurs, but it's the sort of thing where if you have multiple nonprofits that work together, they may agree to establish a group account to kind of help carry each other through the tough times.
Like a captive insurance.
Yes.
Very much.
There are,
All right.
I sit on a board, that's how we do it.
Yeah. So that's it. I'm 15 minutes over time. I apologize, everyone.
I don't think it's you.
Cover it.
Go
I've
ahead.
got, so Damien, what happens if a nonprofit fails to pay their contributions?
So they're liable to pay them. If, for example, even if they dissolve, they're liable for that. So the department can pursue those contributions, assuming there's no way to get them back. That's a hit to the fund.
So that means that the private sector is paying.
It means
For that.
Yeah, it gets socialized across the fund. The other thing that reimbursable employers avoid are some of the sort of carrying costs that come with the fund. So they're just paying their benefit costs. They're not paying these socialized expenses in the fund from fraudulent claims that aren't recovered or overpayments that aren't recovered, et cetera. So
we could, there's sort of a similar parallel though to a business that has had a decent experience rating that closes or dissolves, right? They're not gonna then have the increase to reflect their.
Right, so if you have a major employer that, you know, goes out of business and is bankrupt, you may not be able to get, you know, that cost is gonna end up being socialized in the fund because there's no one to tax in the coming year. Your hope to some extent is that in paying taxes over the years, they've sort of cushioned the fund against that blow. One of the things that you do see talked about on the national level is this question of, is your high tax rate actually covering the cost of that's attributable to the employers who are at the highest tax rate? Or is their experience so bad that they're actually costing the fund more than they pay in? And that's another, again, it gets to this whole financing picture. And it's part of what makes it so complicated is, you know, what's appropriate for an employer, a really good experience rating to pay. And on the other hand, are you charging the employers who have really bad experience rating enough? Or are they actually getting a subsidized ride on the system? You know, and is there an appropriate level there too, so the tax rates are not so high that they're detrimental to the ability of some of these businesses to continue operating so that they can continue paying in and so forth.
Can we get an idea, is the state of Vermont a reimbursable employer?
Yes,
Is medical center a reimbursable employer?
that's a great question. I don't know.
If we could get some idea of some of our bigger employers, whether they're reimbursable employers or not. I mean, we face this issue in healthcare. You know, are we gonna, if some of the bigger players opt out, it makes it harder for the little guys sometimes. So just get an idea of how much this is being used. And is this a mandate that every state has to offer reimbursable employer options?
Let's go back to the federal law here.
While you're pulling that up, we're doing some background research with the department and with Joyce in order to get a better sense of what the scale looks like here.
Okay.
As it within Vermont and who is actually impacted.
Yeah, we have to provide nonprofit organizations with the ability to elect to reimburse. That is a federal requirement.
Okay.
So, yeah, and the one thing I would just note is we can probably get de-identified information because of some of the UI confidentiality rules. I'm not sure we can actually be told that X organization is a reimbursable employer. The state is an easy one. I'm not giving anything away because that is what the statute requires the state to reimburse. So that we don't have an option otherwise under the statute. So, but nonprofits and local governments, the department can probably give you a better idea of what the universe is and the number of reimbursing employers. Or Joyce.
With that, I think we're going to take a break. That was a lot of talking. Thank you, Damian.
Welcome. We'll get a lot of these about to run out.
Yes, we will come back at 11. If that clock is ready, which it is, yes.